Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals. Testing 1 2 3.
We are going to begin with appeal number 21-3224, United States versus Anthony Pemberton. We'll hear first with oral argument from Mr. Leon.
Good morning, Your Honors, and may it please the Court. The question here is whether Mr. Pemberton's conviction under Indiana's 2003 conspiracy statute categorically fits within the 1994 Three Strikes Law. The parties' agreements here clear much out of the way for the Court in completing that analysis. In fact, each relevant premise on appeal for Mr. Pemberton's conspiracy argument is undisputed. So I think it's helpful to walk through each relevant premise. The parties first agree that the Taylor categorical approach and the generic definition approach apply and govern the analysis. We then agree that Indiana's 2003 conspiracy statute punished what I've called a unilateral conspiracy in the briefs. We then agree that Indiana's conspiracy statute is categorically broader than any bilateral conspiracy provision.
Mr. Leon, there's been no Indiana law beyond this Tidwell case that speaks to this unilateral versus bilateral question?
No, Your Honor. I think there are multiple Indiana Supreme Court cases that we've cited in the briefs that address this unilateral and bilateral question.
And where does it land?
It lands that Indiana is a unilateral conspiracy statute. So I think the dispositive question left here is whether the 1994 Three Strikes Law's generic conspiracy is a bilateral conspiracy.
Mr. Leon, before we go too far down the merits, why haven't you forfeited this argument by not raising it below?
Your Honor, we preserved our serious violent felony claim in the district court. In the district court, we argued first we objected to the 851 enhancement.
Right.
And then we argued that the conspiracy conviction is not a serious violent felony under the enumerated offenses clause of the 1994 Three Strikes Law. On appeal, we're doing the same thing.
But you're really not, because below you argued that it didn't qualify for factual reasons because your client wasn't possessing the gun. Here you're raising really a separate legal argument under the categorical approach. How does that preserve it?
I would point this court to Billups and Wanjuku. So in Billups, the defendant in the district court argued that a false imprisonment conviction did not qualify as a crime of violence. The argument he gave in the district court was that this is a force problem, a use of force problem. On appeal, he came and argued something about consent, completely different. And the court said that is enough under View, Yee, and that line of precedent to preserve the objection. And Wanjuku is also helpful. In that case, the government argued that, in the district court, the government argued that the defendant's Fourth Amendment rights were not violated. Then once it got on appeal, the government argued that the good faith exception applied.
Mr. Leon, let me ask you a similar question. The argument that you made, as Judge St. Eve is indicating in the district court, is that the safe harbor under 3559 was satisfied, correct? 3559C3.
I would phrase the argument as it doesn't fall within the enumerated offenses clause because of that reason.
Right, okay. And the reason that you focused on was the safe harbor.
That's correct.
And the facts of the underlying offense.
That's correct.
Okay. The difficulty that I have with the argument that that your position that it's preserved is that the categorical approach, if it's nothing else, is not about the facts of any particular case. The U.S. Supreme Court has told us that over and over and over again. So how can we say that at a more general level, your argument that this does not fit within the enumerated offense clause preserved a categorical approach argument? I don't see it.
Your Honor, I agree our argument did discuss the facts some, but we discussed the categorical approach below. And the government even argued that the categorical approach applied in that instance. So this is not something
But the categorical approach applying does not preserve an objection that you think you can't get the enhancement because of it. In fact, when the government said the categorical approach applies, you didn't object on that basis.
Well, Your Honor, the government has cited no case in the Seventh Circuit that supports this position. It's only cited out-of-circuit precedent, and under this court's precedent, it's already drawn these lines. Billups and Wanjuku drew the lines relevant for this case. This is not a forfeiture case. But even if,
Do
let's
you
assume,
agree that there's nothing you argued before the district court that would have alerted the district court to address this issue?
no, I disagree. We mentioned below in the district court that a conspiracy involves two or more persons, so I think that put the district court on notice. But I think the
How
elephant in
would
the
that have put the district court on notice to address the bilateral versus unilateral categorical approach argument?
Because,
There's
Your Honor-
nothing that was even mentioned bilateral versus unilateral.
Because, Your Honor, for 200 years, conspiracy in federal law has meant this. This is the first court that I can find ever to rule so. So the district court did something here that no court has done in a federal context. But even assuming forfeiture does apply, and I strongly disagree with that.
Well,
But
let's assume it does apply and plain error applies. How do
Okay.
you win?
So the government has not disputed prongs 3 and 4. That's undisputed on appeal. And the government, for prong 1, is basically what we're talking about, that I think the categorical approach argument is really strong. So then we get to prong 2, which is whether the error is clear. And here, the government still hasn't disputed prong 2 under the correct generic definition analysis. It doesn't dispute that the 1994 generic definition was bilateral. It asks this court to avoid Stitt, Esquivel-Quintana, Van Cannon, and other binding precedent that says you adopt the generic definition in effect at the time of enactment. What the government has argued here is that it wants the court to adopt a 2023 version of the generic offense. And that's barred by, as I said, Stitt, Esquivel-Quintana, and this court's precedent. So the only thing the government has left on its side is the 1962 Model Penal Code's unilateral view. But Congress rejected that for 32 years, day in and day out. And it wasn't like there was a turning point in 1994. Congress then rejected the Model Penal Code's view for another 30 years after 1994. This court will become the first court to hold that federal conspiracy covers a unilateral conspiracy. I can find no others. So I think that's why we would win under plain error. And I would point the court to Ruth, for instance. The subject matter doesn't matter for the plain error analysis. In Ruth, this court held that it was plain error for the definition of isomer. And that is really far or broad when it comes to whether a district court's going to notice something. Here we have conspiracy 101 in federal law, and the district court just didn't see it. And that's okay, but that's why we have appellate courts, to make sure that the law is applied correctly. And so I'll just conclude very quickly, Your Honors, that three strikes conspiracy is bilateral. Every other conspiracy in federal law is bilateral. A majority of jurisdictions in 1994 was bilateral, and that ends this case. Unilateral conspiracy in Indiana is broader, and Mr. Pemberton's conviction does not fit within the 1994 three strikes law. I reserve the rest of my time for rebuttal.
Very good. Thank you, Mr. Leon. We'll next move to Ms. Spiro.
Thank you, Your Honors. May it please the Court, Samantha Spiro on behalf of the United States. As you've noted, the preliminary issue here is that the defendant has forfeited the argument below, or forfeited the argument he makes now. The argument that the defendant made below presupposed that some Indiana conspiracies could constitute serious violent felonies. It's just his didn't, based on the facts. That was his argument below, and he now argues an inconsistent argument, which is that no Indiana conspiracy whatsoever could be a serious violent felony.
What do you think about his analogy to the Ruth case?
I still think under the plain error, I think the law is very unsettled in this, at least unsettled in this area, and so under plain error, he just can't succeed. I do think we do agree that you have to apply the categorical match or the categorical approach in this case because Congress did not define conspiracy with regard to a federal statute or at all. And so under the categorical approach, you have to look at the ordinary, commonly understood, generic meaning of conspiracy. And our position is whether you look at that in 1994 or you look at that in 2023, the commonly understood, generally accepted meaning of conspiracy included both types of conspiracy, both unilateral and bilateral.
Don't you think 1994 is the proper measurement date?
Our position is that it's not dispositive what date you look at. You can look at 1994 or 2003 and all of the sources to which Taylor and Esquivel-Quintana instruct us to look at point towards unilateral conspiracy being the accepted, being part of the accepted version of conspiracy.
The Solicitor General of the United States in the Stitt case took the position that the relevant measurement period is the date the statute went into effect. And that makes good sense to me.
So we would acknowledge that that's what it said in the Stitt case, and our position is that if you look at the statute, or if you look at federal generic conspiracy in 1994, based on all the sources that Taylor asks us to consider, it's still unilateral conspiracy. That is the generic, commonly accepted version. And even the defendant acknowledged that starting in 1960, the states were trending towards a unilateral version of conspiracy. The Model Penal Code accepted the unilateral version of conspiracy.
What do you think the state of the law was in 94, focusing on 18 U.S.C. 371?
So I think 18 U.S.C. 371, we would agree that the courts have held that that's a bilateral statute. But Congress knew how to define crimes, predicate crimes, with reference to specific federal statutes. It did it in the statute, in the three strikes law itself.
Isn't that a heads I win, tails you lose argument, though? Because the conspiracy then would be defined different places in the statutes and the guidelines.
So I think our position is that Congress didn't define conspiracy in the specific three strikes law. Instead, it wanted to encompass state crimes by whatever name and whenever committed. And I think that's extremely broad language, and that's part of the reason why it wasn't referencing a specific federal statute. And the courts haven't looked specifically at any federal statute in defining the generic version of these crimes.
Right, but for purposes of trying to figure out what the federal generic is, right, you're looking at the term conspiracy as it applies in 3359C2, right?
Correct.
Okay. And do you agree that 371 case law is relevant to that consideration?
Yes. I mean, we agree that it's relevant, but we don't agree that it's the only consideration. There are a number of considerations that, for example, the Taylor court looked at. It's not just the statutory federal law.
No, fair enough. I just wanted to be sure that your position was not limited to Title 21.
No, Your Honor. So again, all of the sources considered in Taylor and Esquivel-Quintana point to the fact that the law is at the very least unsettled, and because the law is at the very least unsettled, the defendant can't succeed on the plain error standard. I would also just finally point to the purpose and the text of the statute again, which is extremely broad, and the courts have recognized there's not a counterpart in many of the other statutes where we're applying the categorical approach. Congress intended to capture state crimes by whatever designation and wherever committed, and it sought to encompass a wide variety of state crimes. And so we believe that the defendant, based on all of those factors, can't succeed on plain error, and we ask that you affirm the district court.
In Esquivel-Quintana, the Supreme Court found that there were 30 states and that a shared consensus among those 30 states as to a particular meaning was a significant majority. Here we have 31 states back in 1994 that followed the bilateral approach. Why wouldn't that be enough for plain error?
So I think in Esquivel-Quintana, they did look at the number of states as a relevant factor, but they also considered the other context and the other factors that we've discussed. So in Esquivel-Quintana, they considered the dictionary definition. They considered the trend from 1996 to today. And so it wasn't just dispositive that those 30 states went a certain way. And in this case, we would argue that there's a relevant trend here, and the relevant trend is towards, it's only gone one way, and it's gone towards acceptance of the
That's
unilateral.
only relevant if we don't just look at 1994 when it was put in place.
So I don't necessarily agree with that. From
Why?
starting in 1960s, as the defendant acknowledged in his brief, some states were beginning to change towards a unilateral approach. And the Model Penal Code was drafted in 1962, and it accepted unilateral conspiracy as an acceptable form of criminal conspiracy.
Thank you, Ms. Spiro.
Thank you, Your Honors.
Mr. Leon, we'll go back to you for rebuttal.
Thank you, Your Honor. 2 quick points. 1, to create the generic definition, we looked at 3 things. Federal law, as Judge Scudder has pointed out, and I said earlier, it's been unanimous for 200 years. Congress doesn't punish unilateral conspiracies, and that has to be true in this case, where the mandatory 3 strikes law results in life imprisonment in many cases. 2, my colleague here talked about how there's a trend that's irrelevant. The question is, what was the status of the law in 1994? At that time, the government has not disputed that at least 30 jurisdictions followed the bilateral approach. So we have unanimity in federal law in 1994, and we have a majority of jurisdictions in 1994 that are bilateral. That's the end. There's no categorical approach case that I can find or that the government has cited in which the Supreme Court took the minority view to create the generic view. That's the exact opposite of what is generic. And that's true under any standard of review. As I said before, and I want to make clear, the government hasn't disputed prongs 3 and 4. Prongs 1 is just the de novo review. And in my view, the government has conceded prong 2 as well. With no further questions, Your Honor, I rest on the briefs.
Thank you very much, Mr. Leon. Thank you, Ms. Spiro. The case will be taken under advisement. We're now going to move to Appeal 22-2975, Nathan Pati versus Kijakazi. And we'll begin with oral argument from Mr. Rodman, who I don't see present here in the gallery. Let's give him 1 minute to see if he comes in. Otherwise, we'll move to the third case, Kirby. Yeah, I don't see him. All right, why don't we move to our third case of the morning, United States versus Kirby. This is Appeal 22-3037. That matter was submitted on the briefs. We'll then move to Appeal 22-3070. This is United States versus Robert Prieto. We'll give... oh, very good. We're going to go ahead with case number 4 then. Thank you. We're going to begin with oral argument from Ms. White. Thank you, Ms. White, for your flexibility.
Of course, thank you, Your Honor. Good morning.
Good morning.
May it please the court. My name is Cece White. I'm here on behalf of the appellant, Roberto Prieto. We're here because Mr. Prieto was convicted of 3 counts of felon in possession of a firearm. And we're here specifically on 2 sentencing enhancement issues, the trafficking enhancement, as well as the enhancement for the number of firearms. I'll begin with trafficking. The rule in the guidelines for trafficking is that the defendant transferred 2 or more firearms to another individual and knew or had reason to believe that that conduct would result in the transfer to an individual whose possession would be unlawful or who intended to use the weapons unlawfully. It was applied in this case because of unlawful possession of the recipient of the weapons. The guidelines really narrowly define what qualifies as unlawful possession. The person must have a prior conviction for a crime of violence, a controlled substance offense, or a misdemeanor domestic violence offense. Or they must be under a criminal justice sentence at the time of the offense. Here it was a criminal justice sentence, specifically parole. I want to focus on the knowledge or belief component of this requirement. First, they must have transferred these 2 or more firearms, but the knowledge or belief as to the recipient's status as an unlawful possessor must also apply to the transfer of at least 2 weapons.
Ms. White, is your argument grounded in the temporal delay, the 13 months?
That's correct, Your Honor. So we have June 2022, we have 1 transfer of a firearm. And then it's over a year later when we have a second transfer of a firearm.
How short is too short? How long is too long?
I would say that 13 months is too long. With something like parole, I think we would need proof in the second transfer, or at least the transfer of 2 weapons, to show that there was a reason for the defendant to know or have reason to believe that that was still in effect. So here it's June 2022 when the CS, the confidential source, tells the defendant that he's on parole. Over a year later, he has no reason to know that that status persists.
How would you articulate, take Judge Brennan's question just a little bit broader, how would you articulate that dividing line? Because our case law, if you look at Wallace and Santoro, cases like that, 6 to 9 months has been enough. How would you put into words what that dividing line is?
I think that the dividing line depends on which of the 2 statuses are being used for the enhancements application. So if it's intent to use the firearms unlawfully, then I can see a much larger period of time. Because that, if that intent is expressed, and then 1 year later those guns are sold to the same person who expressed an intent that they're going to use the weapons they receive unlawfully, I can see how that would still be in effect. But because the guideline really specifically says that it must be at the time of the offense that they were under that criminal justice sentence, I think that changes the line and makes it a much shorter period of time.
Is the temporal analysis any different on the other enhancement at issue in the case?
The number of weapons?
Yeah.
No, I don't think that the time gap changes anything because they are all related. What we really dispute in the number of the weapons has less to do with the time gap between the transfers and more to do with the 3 weapons that were not ever transferred. So I don't think in the number of weapons the gap has an effect.
Yeah, you've never argued that anyway.
No. But
How do you respond to the argument that the language of the statute says that he had reason to believe that such conduct would result in the transport, transfer, or disposal of a firearm to an individual? So that all that it matters is that he knew he was on parole or had reason to believe he was on parole in connection with one sale.
I do acknowledge that the First Circuit has now held as such, and the Second Circuit did mention it in dicta of a case very recently. But other than that, I've actually not found a case where it's been applied in that manner, and it wasn't applied.
Rejected. I don't think there are any cases rejecting that. But what is your argument as you stand here today as to why, based on the plain language of this provision, why would it has to apply to both firearms?
I think the language "such conduct" is what dictates that result. So, the first prong being the transfer. The second then says that knowledge or belief is that such conduct, and the conduct has been defined as the transfer of 2 or more weapons. So while it does say a firearm in that clause as well, I think such conduct refers back to that first clause, which is quite specifically the transfer of 2 or more weapons. I also think the fact that it says at the time of the offense in the definition of unlawful possessor supports our argument as well, because the time of the offense, the time of the transfer of 2 weapons, is relevant here. In the June 2020 transfer, he has that knowledge or belief, but he no longer does 13 months later. I think this is relatively specific to the unlawful possession prong of this, because that is where it says at the time of the offense. I will move on to the number of weapons.
We're really at issue with those 3, correct? The 6th, 7th, and 8th one is what you're disputing, correct?
The firearms?
Yes.
So there are 5 firearms that he pled guilty to possessing. Those are not in dispute. The 3 that in dispute were offered in a text message for sale, but it was clear from the evidence that he didn't have actual possession at the time of the messages. He's referencing someone else who has the weapons and the fact that they may be sold by that other person. So they're not in his control or in his possession, and the district court did appear to agree that there was no possession. So then the other issue has become whether there was proof that they were unlawfully sought to be obtained. And the guideline is really specific that there are only 3 categories that can be counted under this enhancement, and that's unlawfully possessed, unlawfully sought to be obtained, or unlawfully distributed. So here, the government has relied on sought to obtain. The issue is that there was no evidence at all of what efforts he made to obtain these weapons. There was no text message or information on who he was getting them from. We know nothing about the actual efforts to obtain them. All we have is a text message saying that he will sell them.
This argument seems a little bit different than what was argued before the district court.
It is not different than what was argued before the district court, Your Honor.
The focus below seemed to be on unlawful possession rather than sought to obtain.
In the sentencing memo, the focus was on unlawful possession, but in the oral arguments, because the defense did file their memo, our memo first. So then when the government raised their argument that it was unlawfully sought to obtain, the oral argument did focus on both. I would direct the court to page 14 of our appendix to see that portion of the argument. But the main issue here is that offering them for sale does not prove that he took steps to obtain them or that those steps were themselves unlawful, which is what the guideline requires.
Why can't you infer that he took a step to obtain them after, given that the June 2020 sale had already occurred?
The June 2020 sale had no mention of other weapons that would later be sold.
No, fair enough. But when a person that you bought a gun from, or the defendant sold to, and then he's re-offering less than a month later, well, he's obviously in a position to get a gun because he just sold one.
I think the issue is that the guideline doesn't say attempting to possess or the intent to possess. It does say that he has to unlawfully seek to obtain it, and we have no proof of what he did to seek to obtain it. So he may have told someone he plans...
Even though he was marketing a second gun after a first sale.
That is all they have, yes. That is the evidence before us. But in cases that have interpreted what qualifies as sought to obtain, there's been significantly more evidence. Maturino, which we mentioned in our brief, there was significant
But
evidence
here
showing...
it's just, was the district court's determination clearly erroneous? And you have the texts that include the photos, they discuss and plan to meet, you have prices offered. Why would that be clearly erroneous to conclude?
To conclude that those weapons were involved in the offense?
Yes.
Because we know nothing about how they were sought to obtain, and it must be unlawful. The seeking out of the weapons itself must be unlawful.
But as Judge Scudder pointed out, you already had that first sale.
Right, but the sales were not, like in Burke, for instance, the sales were premised on one another. It was a shotgun in exchange for 2 future handguns. In this case, there's no connection between the sales, and other than the first and second, they're separated by 13 months. And the second sale never took place. We know from the evidence that it's because the weapon was in someone else's possession and that person sold the weapon themselves. So there is no possession, and we have no information at all about the efforts that were taken to obtain the weapons, including who they were from or what their source was. So they just failed to prove that it was unlawfully sought to obtain.
Would you like to reserve the remainder of your time?
Yes, thank you.
And we'll be giving you some more rebuttal time, Ms. White. We'll next move to Ms. DeMarco for argument on behalf of the government.
Thank you, Your Honor. May it please the court, Megan DeMarco for the United States. I'll begin with the trafficking enhancement. The defendant in this case transferred 5 firearms to a confidential source. For at least one of those firearms, the source explicitly told the defendant, "I am on parole," essentially. Under the plain language of Application Note 13, that is sufficient to apply the enhancement in this case. The plain language states that 2 or more firearms must be transferred, which no one's disputing here that 5 were, and that conduct must result in the transfer of 1 firearm to someone whose possession would be unlawful, including someone who's on parole. So the government's position is the plain language of the guidelines supports the enhancement in this case. Even if
it has to be during both of the transfers, the district court here didn't say a lot about why he would have known the confidential source was on parole or why he had reason to believe during the second sale. What's your strongest argument for that?
Your Honor, I think our strongest argument is that the confluence of factors here gave the defendant reason to believe a year later, and the district court did say his belief was sufficient. I agree that it was not a lengthy explanation, but the district court did say he had reviewed the PSR, the government sentencing memo, and focused in on the defendant's belief being sufficient.
What are those factors?
Yes, Your Honor. The factors are that a year earlier, the confidential source said explicitly, "I'm on parole." He mentioned that he had warrants. The defendant himself had served more than one term of parole that lasted longer than a year. He had served one term of parole that was actually 39 months, more than 3 years. And finally, the circumstances hadn't changed between the first set of transfers and the second, transfer 1 and transfers 2, 3, 4, and 5. The confidential source and the defendant picked up exactly where they had left off a year earlier. So in the defendant's mind, there would be no reason to think that any circumstances had changed, including the status of the CS, taken together with the CS's explicit statement that he was on parole, that he had warrants, that he had a criminal history. So the government's position on the trafficking enhancement would be that the plain language supports the enhancement of only one firearm transferred with that knowledge, but even if, as defendant suggests, that knowledge needs to, or reason to believe needs to carry over for all of them, that combination of factors would support the enhancement. If there are no other questions on the trafficking, I'll move on to the other enhancement.
That's fine.
The defendant transferred 5 firearms. I think that's not in dispute. The other 3, for each of them, they followed the same pattern, the same modus operandi, and they hit the factors that this court has said are relevant for considering relevant conduct. They're temporally similar, that they occurred with regularity, and they occurred following the same pattern. So for the 6th gun, that's the one that was less than a month after the first transfer. The defendant did the same thing that he had done when he had sold the first gun. He texted the CS, he mentioned the price, he sent a photo, he offered specific details. The CS then has a conversation with the defendant over the phone and tells the agents, we're going to meet up the next day, the sale is going to be finalized. Due to circumstances beyond anyone's control, that sale is never executed, the defendant's arrested. But the government's position is that based on the similarity of the conduct to the first sale, the temporal closeness of it, its relevant conduct, the defendant clearly took steps, sought to obtain that gun.
Where do you think the line is on the temporal proximity? Well, how much time is too much time to go by?
Well, Your Honor, I think in this
The reason I'm
case-
asking that is I think it's a difficult question. You may be okay here, but I think it's a difficult question on the intersection of 1B, what is it, 1B3, the relevant conduct rule, or whatever that is. Mm-hmm. The application of the relevant conduct rule vis-a-vis 922G, because 922G is a status offense, right? The offense is committed and completed the moment a prior felon is in possession of a firearm. And then if that clock keeps running, relevant conduct-wise, to add in, the additional guns for purposes of the enhancement, what I wonder about is when too much time has gone by. What do you think on that?
Yes, Your Honor. I think, well, it's two things. I think in this case, the temporal proximity is pretty close. The first one is only 3 weeks later, and in the second set of transfers that are at issue, it's 6 days earlier than the ones that occur following that. I would also point out that this court has said that this is, there are 3 factors that matter, and not all 3 have to have the same strength. If one of them is missing, the other 2 can make up for the lack of that. So, for example, because these are regular and occurring in the same pattern, that factor might be a little stronger than the temporal factor. And so I think the government's position would be that even if there's some question about the temporality, the regularity would make up for it.
Yeah, so let that case come to us where the question's harder, and we'll figure it out then.
Well, I think in this case,
It's a hard question. I don't know. I don't have an answer. That's why I don't know. I think you're absolutely right that the time is close here, and that's a fair argument. I just wonder how we articulate where that outer edge of that is.
I understand, Your Honor. I think in this case, you don't need to reach that question because it is fairly temporally close. And in terms of the facts of the 7th and 8th firearm that are disputed, the defendant, again, texted a photo to the CS. He actually used the words, "I got," in reference to the firearms, which is the same language that he used in reference to the firearms that he had actually sold the CS. So the government's position would be that that language manifests either actual or constructive possession. We actually don't know whether the defendant had the guns and sold them to someone else or his supplier just never delivered them to him. But in all 8 of these transactions, he mentions a supplier. And so the government's position is that the unlawful.
I mean, inherent in all those text messages, if we circle back to where we were, is that he's in a position to acquire firearms to then in turn sell to people.
That's exactly right, Your Honor. And that's exactly how he approached the firearms that he did sell, was to tell the CS, here's a photo, here's a price, my supplier will drop it off.
So implicit in that is he must have done something to obtain them.
Exactly right, Your Honor. So the government's position is that based on the regularity of the sales, the defendant certainly sought to obtain them. If there are no other questions for me, the government would ask you to affirm the sentence of the district court.
Thank you very much, Ms. DeMarco.
Thank you.
Ms. White, we'll go back to you. We'll give you 2 minutes for rebuttal.
Briefly, Your Honors, I want to just address what was just being discussed, the fact that he was in a position to obtain weapons. We do know that he obtained and then transferred 5 weapons, but the issue is it's pure conjecture that the other weapons were ever obtained. And it is required that it be not only that he sought to obtain the weapons, but that his efforts to do so are unlawful. And here we don't have any information on what efforts he did take to seek to obtain those. It would be conjecture to say that he had all of these deals going on because we know nothing about those deals. There was never any information about whether it was one supplier, multiple suppliers, how he got a single one of the weapons.
Focus on it's interesting that you put a lot of emphasis on the unlawfully. How could he lawfully ever obtain a firearm as a convicted felon? What would be that scenario?
Well, Your Honor, the burden is on the government to prove that it was unlawful.
Fair enough. Give me the fact pattern where it would be lawful for him to obtain a 9mm to sell to somebody.
I'm not sure that there is one, Your Honor.
Right. So why the emphasis on unlawfully?
Because in every case that where that has been in dispute, this court as well as others have required that it actually be shown that it was unlawful.
Well, isn't it shown by virtue of his status as a prior felon?
Well, in this case, in the unlawful element of the unlawful possession of the recipient doesn't have a bearing on the status of the defendant as a felon. So it depends which unlawful possession we're talking about. The transferee's unlawful possession, the felony status of Mr. Prieto has no bearing. When it comes to whether or not it was an unlawful seeking to obtain for Mr. Prieto, that's where it could come into play. And the problem is
right, and throughout the relevant period, he's a convicted felon.
That's correct, Your Honor. But when it's unlawful possession, even because of a convicted felon status, courts require that that be proven. And here there was no proof offered that there was any sort of violation of a statute or any law in his seeking to obtain because we have no information.
What about 922G? He can't. There's no circumstance under which he can acquire a firearm.
Attempted possession is not a part of 922G. So we don't know anything about the efforts he made, but he did not possess the weapon. So for it to be unlawfully sought to obtain, the guideline just doesn't include attempted possession as one of the potential firearms to be counted under this enhancement. As far as the parole status, the government stressed that there was no way of knowing. There was no way for the defendant to know that anything had changed between the beginning and 13 months later. And because he could have already been on parole for years already at that time.
Thank you, Ms. White. Thank you, Ms. DeMarco. The case will be taken under advisement.
Thank you.
Ms. White, thank you very much as well, counsel, for your help in this case. We understand you've been appointed. We thank both you as well as your law firm for your excellent advocacy in the case. And thanks as well to Ms. DeMarco. We're going to move back now to case number 2. This is Nathan Pattee versus Kijakazi, Appeal 22-2975. And we're going to begin with oral argument from Mr. Rodman.
May it please the court. My name is Jason Scott Rodman, and I represent the appellant Nathan Frank Pattee. This is an appeal of a Social Security disability case. It is a Step 5 case. Really, it's one argument today, and it's fairly simple.
Hold on. A Step 5 case?
Yes. And so at the fifth stage of, it means it got past the first 4 steps, and he, well, I mean, first,
I thought it was
Go ahead.
a listing case, a 405 listing case, and an RFC case.
so it could well be a 405 listing case and an RFC case.
Well, hold on.
Your Honor.
Yeah, what do you mean could be? You submitted a brief.
Correct. So in order for those issues to be properly adjudicated requires a medical review is the position of the plaintiff, Your Honor. And so and also some of this is so those issues are in the briefing. The way the administrative law judge decision is written up puts it as a step 5 case. So there's a little bit of a semantics issue. But I agree with you because this case is about the simple argument that with the new positive tilt table testing, there was due medical review instead of simply the administrative law judge, assessing on her own accord.
But she didn't assess it on her own accord. It's clear that she relied on his own treating cardiologist in reaching her determination, and that his own doctor actually saw the tilt test results and said that the medication was largely controlling any symptoms he had after the tilt test.
Okay, so I would use the language from the court's Moreno decision to answer that point, which is that that argument is based on the administrative law judge's own assessment of the recent record, and so.
But it's not her own assessment. It is the specific assessment of his treating physician.
It is picking and choosing that there was an exam where some.
How is that picking and choosing when the treating physician, the treating cardiologist, actually saw the results of the test and made specific entries about his medication largely controlling the conditions after that test? And that's what the ALJ relied on. She didn't come up with something on her own.
Later in the case, we saw evidence that while the medications may have helped, they did not resolve the symptoms. And
his own treating physician said the medication largely controlled his condition.
Right.
After that treating physician saw the results of the tilt table test.
The very next day, indeed.
Well, but keep in mind, the nurse practitioner Fox, and this is in the reply brief in detail, picked out what she thought was going on with this plaintiff and began giving plaintiff the medications before the positive tilt table test. And even with those medications, the tilt table test was still positive, which is to say, medications were not needed after that tilt table test, but that's because nurse practitioner Fox had sort of had a gut feeling, as far as the record suggests, as to what was going on. But the symptoms were not resolved, and the test that the ALJ is relying on is specifically a medium RFC, which is quite substantial and which is based on significant portions of that treatment before significant portions of that treatment. So the medical reviewers did not review big portions of that stuff, most notably the tilt table test, Your Honor.
So, Rodman, can you help me out on one thing?
Sure.
In your brief, in several different places, you refer to this case as an etiology case. You know what I'm talking about?
Yes, Your Honor.
Okay.
So,
Tell me what you mean by that.
okay.
What do you mean that this is an etiology case?
Yes, it's absolutely an etiology case.
Just tell me what you mean. You've said that, but I can't figure out from your brief what it is you mean by that.
Okay, so I know you know this, but so to articulate to help you understand what I'm trying to say, etiology is how, the process by which doctors determine what is causing what. And so you might have many tests that come up negative and normal, And that doesn't thereby mean that a Social Security disability claimant doesn't really have conditions, because the next one might really illustrate an underlying problem that the others didn't get to. And so the administrative law judge decision, when you read it, it addresses big areas of different etiologies, if you will, from pulmonology narrowly to cardiology narrowly to mental health narrowly. And the tilt table test is suggestive of something deeper and underlying. And I'm not a doctor, so I'm not going to even be the person to tell you exactly what that is. But it's my position, it's plaintiff's position that was due medical review. Any further questions for me?
You can reserve the rest of your time if you wish.
Thank you.
Thank you, Mr. Rodman. We'll now move Ms. Payne to you.
Good morning, Your Honors. May it please the Court. Lindsay Payne on behalf of the Acting Commissioner of Social Security. This case comes down to the standard of review before this court and the burden that Mr. Patty bore before the ALJ. The ALJ's decision should be affirmed because it's supported by substantial evidence, which is not a high bar. And crucially, that inquiry should be made from the point of view of the ALJ with the information that she had available to her at the time that she rendered her decision, not based upon hindsight or documents that were developed after she rendered her decision. Now, in argument here today, Mr. Rodman doesn't seem to have focused on his theory that Mr. Patty might have postural orthostatic tachycardia syndrome, or POTS. So unless the court has questions specifically about that, I would boil the argument from Mr. Patty down to the suggestion that regardless of the diagnosis, the tilt table study itself required an additional medical source opinion.
Can you just confirm one thing, though? I don't see anywhere that there was a medical diagnosis, and I think you make this point. I just want to confirm it. There's not a medical diagnosis of POTS, correct?
Correct.
Okay.
There's no diagnosis either before or after the ALJ's decision of POTS. Now, what we do have is that Dr. Shirazi, who administered the tilt table test, and Dr. Wilson, Mr. Patty's cardiologists, agreed that the tilt table study showed neurocardiogenic syncope, in other words, that he fainted, but that he does not have a cardiac or neurological defect causing that. It's essentially the medical word for fainting. At that time, Mr. Patty had been already taking medication for lightheadedness for about 5 months already. So contrary to what he's saying here today, there wasn't some big change either from the tilt table study or from nurse practitioner Fox when she ordered the tilt table study. Mr. Patty was first diagnosed with orthostatic hypotension, meaning that he experienced a drop in blood pressure when he stood up. That was by Dr. Ransbottom, his general practitioner, in December 2019. So that's when Dr. Ransbottom started him on this medication for his lightheadedness, the same medication that Dr. Wilson said was continuing to control Mr. Patty's symptoms at the time of and after the tilt table test.
Yeah, and that seems to me to be a very important fact. Dr. Wilson saw Mr. Pate the day after the tilt table test, and he saw him aware of the results of the tilt table test, and he continued the existing medications.
Absolutely. That is one of the crucial factors that aligns this case with this court's other recent cases, such as Durham, Bakke, and Ducharme, that are discussed in the commissioner's brief, where Mr. Patty's own medical professionals had the opportunity to analyze the test results and to determine whether this was a change in his condition or this was not a change in his condition. Dr. Wilson, the cardiologist, determined it was not a change in his condition. It did not necessitate any change in treatment.
And that's what the ALJ relied on in
Absolutely.
making her determination.
Absolutely, and she had other correlation in the record as well. For example, despite complaints of lightheadedness for some period of time, Mr. Patty told multiple providers that he had never actually fainted or lost consciousness or fallen down outside of the tilt table study. When he went to nurse practitioner Fox in May 2020, at the time she ordered the tilt table study, he initially told her, "I fainted and I fell down the stairs." Upon further questioning by her, he acknowledged he had not lost consciousness. He had not fallen either to the ground or down the stairs. He had felt lightheaded and he had leaned against the wall. Mr. Patty, that's at pages 1930 to 31 of the record. As we discussed at the follow-up visit with Dr. Wilson, if you look at the text of that document, record 1966 to 69, Mr. Patty's saying he's not experiencing syncope, near syncope, or falls. In February 2020, he tells Dr. Ransbottom at page 1932 of the record that he had never actually, quote unquote, passed out. So all of this evidence then corroborates what Dr. Wilson said about there not being a change in condition that was uncontrolled by his medication, and lends further credence to the ALJ's decision that she could rely on that interpretation without needing additional medical opinion evidence.
Now, isn't Dr. Lutz relevant to this too?
Yes.
Because after the tilt table test, he sees Dr. Lutz as well. And Dr. Lutz doesn't report any. I know that's a different discipline, right? He's a neuropsychologist.
Correct. But
there's nothing abnormal there either.
No, and it's definitely relevant that it occurred after the tilt table study. Mr. Patty alleges, well, no one
2 days after.
Yes, no one informed Dr. Lutz about the tilt table study, but Dr. Lutz was not a practitioner who was obtained by the agency to examine Mr. Patty. He was his own provider, so who other than Mr. Patty was going to inform Dr. Lutz if he thought that the tilt table study was so significant? It would have needed to be Mr. Patty. And in the formal neuropsychological testing by Dr. Lutz, he determined there was no neurological problem, which is what Mr. Patty was saying he was concerned about. There was no evidence of a hypoxic brain injury, which he continues to put forward as a theory of what could have been causing his symptoms. And instead, what Dr. Lutz determined was what Mr. Patty's providers had been saying all along, which was that he was having depression, he was having anxiety, and he was refusing to treat the cause of what he was feeling. Dr. Patty also noted that the testing showed that Mr. Patty was not making adequate effort in the testing. This wasn't just a gut feeling by Dr. Lutz. This was determined through specific measures of test validity that are designed to determine whether an impairment is causing the deficiencies in his answers, or whether it was rather a lack of effort or even an attempt at symptom magnification. So again, we have this further corroboration that supports the reasonableness of the ALJ's decision that she could safely rely on Dr. Wilson's interpretation of the tilt table study. As the ALJ noted, Mr. Patty repeatedly rejected his doctor's advice. He refused the treatment that they were offering him. He also made repeated inconsistent statements to his treatment providers, such as that he had had a cardiac arrest, a respiratory arrest, or a stroke in 2018 that caused his symptoms. All of these factors put together, reading the ALJ's decision as a whole, supports her judgment that she did not need additional opinion evidence. If there's no further questions from the court, we would ask that the court affirm the judgment below.
Thank you, Ms. Payne. Mr. Rodman, we'll go back to you now for rebuttal.
Thank you, Your Honors. I would draw attention to the Stage case, which is cited, and that case sets out the record in a narrow instance like this one, which is here, like there. The record contains new and significant evidence that reasonably could have changed here the medium RFC determination of the reviewing doctors on which the ALJ relied. And
What do you think the RFC should have been?
well, the RFC, if the claimant were credited, and I'm talking about symptom, I'm not talking about etiology, it would likely have led to excess absences, off-task behavior, and likely at least a lighter sedentary RFC.
Do you make any of those arguments in your brief? That the RFC should have afforded more accommodation in X, Y, or Z form.
The on-point argument in the brief is that the plaintiff should have been credited, and that the Lutz.
But if the RFC is deficient, don't you have to identify how it was deficient and what medical evidence supports the greater accommodation you're asking for?
So, in this instance, no hypothetical was asked below a medium RFC.
But were there any medical recommendations that additional limitations be included?
So,
It seemed to me the ALJ went even beyond those limitations that were recommended by the medical professionals.
Okay, I didn't focus on this, but the brief below focused on this. It's a good brief. The ALJ hasn't clarified, but this answers your point directly, which is that the ALJ hasn't clarified exactly in what way she goes beyond those articulated limitations.
Well, the burden is on you to identify what limitations should have been included but weren't. And I don't see any argument that there are limitations that were supported by a medical professional that were not included.
The argument is that there is new medical evidence. That is the main and the lead argument.
But there's nothing in the TILT test that says there should have been additional limitations.
Well,
and no doctor has said, based on that test, there should be additional limitations.
But that's true of an MRI, for example, in the
Mr. Rahman,
stages.
I have the same question and the same concern. Do you agree that you have not argued on appeal that the RFC is deficient in some particular way vis-a-vis accommodating your client's limitations? You have not argued that. Do you agree with that?
I defer to my briefs to that. I don't think that's been the core of my
I'm asking
argument.
you
No, Your
about
Honor.
your briefs.
Right.
Because the reason I'm asking you is I thought when I went through your brief that I was going to come to a page because of the dizziness and the lightheadedness that your client suffers from, that you would have said, at a minimum, there has to be a sedentary limitation. And there's not. And all I'm trying to do is confirm that's not an argument you're making.
That is not the core of the argument. The core of the argument is we don't know. We don't know what a medical review with the tilt table test would result in.
The problem is we don't know is not an answer that suffices here because you have to identify a legal error in the decision that you're challenging.
So
right? We're not going to be able to just come to a diagnosis here in the courtroom.
May I finish?
You may.
Okay, so I'm not asking you to come to a diagnosis. In fact, I'm saying that's in fact, I'm saying that it is the doctor's realm. And this case is like the stage case where the plaintiff there disagreed with some doctor treatment. The ALJ used that against him, but there was on-point new evidence.
Okay.
And I thank you for your time.
Thank you, Mr. Rodman. Thank you, Ms. Payne. The case will be taken under advisement. We're now going to move to case number 5 of the morning. This is Appeal 22-3098, United States versus Travis. And we'll begin with oral argument from Mr. Campion.
Thank you. Thank you and good morning. May it please the court. Jamie Travis appealed the district court's finding that Deputy Hobbs' search, however illegal, was ultimately saved by the doctrine of inevitable discovery. That, in other words, there would have been an inventory search conducted on the car after the car that Travis drove was towed to the impound yard.
Mr. Campion, let me follow up on that. Let's presume, just for purposes of this discussion, that the magistrate was incorrect, and that there was problems with the conclusion that Deputy Hobbs did an inventory search. Is your argument that upon the impoundment of the vehicle, of the Prius, that there would not have been an inventory search done by the Sheriff's Department when the car got to impound?
My argument is that there is no evidence in the record that there would have been that search, which we normally view in terms of an inevitable discovery argument, because the policy says this and that. The record,
Well, the policy's in the Exhibit 2, correct?
It is, but in this case, we actually have not simply the dearth of anything that corroborates that, but Deputy Hobbs' somewhat aggressive testimony that I am the inventory search. He said that 4 times during his testimony. So that's my argument. That this can't be saved because we don't have any reason to believe that there actually would have been a second attempt in doing an adequate inventory search.
Can I ask you a similar question?
Absolutely.
Okay, here's what, I'm going to put this very directly, maybe too directly. Okay, but you can sort this out for us. There's no question, you're right, that Deputy Hobbs testified that he believed or he thought he was doing an inventory search, a roadside inventory search. Okay? The legal question I have is, what difference does it make that he thought that? Who cares what he thought? In other words, why don't we just objectively focus the Fourth Amendment analysis on what he did, and then ask the question of did his conduct violate your client's Fourth Amendment rights? In other words, all I'm trying to get at is subjectively, he believed he was doing some kind of roadside inventory search, like a phase 1 inventory search. And my question is, who cares that he thought that?
Well, roadside inventory searches, on-scene inventory searches aren't that bizarre. It happened in Cartwright and in Cherry. Those happened at the scene rather than after it was towed. So they can occur. And we don't have any reason to believe that it would have occurred, because if we look at the policy states all property in a stored or impounded vehicle shall be inventoried and listed on the vehicle storage form. It doesn't say when it should occur. It doesn't say you, the deputy or some other employee of the Sheriff's Department, shall do it after it's towed and impounded. It seems to be able to happen any time. And Hobbs is very direct, and I'm going to use the word again, somewhat aggressive testimony. This is the way it was not, the government did not put anything else in the record to say this actually there would have been a separate search down the line. And they could have, had that been the case, had it actually been the case that there was going to be a separate search when it was impounded, they could simply have introduced into the record the fact of the inventory search at the impound yard.
But you don't have to do that. That's one way, certainly, but why wouldn't the policy here be sufficient to meet that?
Because, again, the policy doesn't state when it should occur, and Hobbs is telling us that it happens with me right now. And if the government was concerned that, wait a second, this is actually not the inventory search, it would have happened. Indeed, perhaps it did happen. That's a matter of getting that in through Hobbs or any other witness that the government could have called had it actually happened. We have no reason to think it actually did happen.
But can you go back to had it actually happened? It doesn't have to actually happen, does it? Under the law,
no.
If Hobbs's search was not proper, but they would have conducted an inventory search properly and found the evidence. Not that they actually did. Why isn't the policy sufficient to prove they would have?
That's the rub, though. The policy says an inventory search shall be done, and it lists all the reasons for doing it and how it should be done. It doesn't say when. And the law...
So is your argument, Mr. Campion, use it or lose it, meaning it happens once and search is singular, not plural?
Well, it could have been twice, but there's no reason to think it would have been twice. Twice seems rather unusual and a waste of resources. But in this case, it did happen the one time. It happened in a miserable way. It wasn't an actual inventory search. But we have no reason to believe that it would have happened otherwise. The policy doesn't say it shall happen later on. It just says you got to do it. Hobbs says he did it. That's the core of my argument. If a search like this, a bad effort at an inventory search, can be salvaged by simply leaning on the policy, and there's no evidence to support that there would have been one, then I lose. But in this case, there's not. It's different than a normal inventory search case where no one claims to have done an inventory search, and a gun or contraband was found, so that it didn't. Who cares what happened? It doesn't matter what did or did not happen down the line. In this case, Hobbs did an inventory search. What he claims was an inventory search, and he found a gun. And there's no reason to think that this was not the inventory search. And as Judge Stadmiller pointed out very clearly, this wasn't an inventory search pursuant to anything close to Florida v. Wells. The video of the search shows Hobbs picking up and tossing items down in the back seat and not going through all the containers in the trunk. His body.
So if that's not a clearly erroneous finding, that it was not an inventory search conducted by Hobbs, then why wouldn't the policy be sufficient to establish that Hobbs didn't do an inventory search, but one would have been done properly?
Well, again, I mean, I'm sorry for maybe I'm not entirely understanding the court's point, but I think in this case we have reason to believe that it wouldn't have been done, because the government witness, Deputy Hobbs, I think he'd been in the force for 2 years at the time. He talked about his experience doing inventory searches. He talked about how he did them. He says, I'm the guy that did it. He had the tow truck driver wait until he concluded his inventory search, and then he testified, after I concluded my inventory search, I let him go. There's nothing to follow that up. There's just no reason to believe it would have happened. If he had, I will admit, I will acknowledge that had he gone about his search and just had the tow truck driver, who remarked with alarming alacrity, it was amazing how quickly he got there. He said, hang tight for a minute. I know we're on the freeway, but just hang tight. I got to go through this, and had his clipboard or whatever and done all those things. And the court found that it wasn't unreasonable for him to have brushed aside the owner of the car's desire to take the car home. Then it would have been a reasonable inventory search.
What about if the gun had not been found on the freeway, but found in the impound lot, in the glove compartment?
Well, that would have been evidence of an actual good inventory, and voila. I mean, that would be it.
Isn't the way to sort through this to you make a very fair point that the inventory search aspect of this is quite messy, but I don't see how the search is problematic as incident to arrest, given all of the questions about the car, the dealer plates, the no insurance, the no driver's license, all of that. So under our reasoning in Edwards, I wonder whether it's just not a much straighter path to view it as a search incident to arrest.
Well, we have to look at what Edwards was about. Edwards was about, I believe, a woman claimed her boyfriend stole her car. So it's a situation where they have cause to believe that this guy may have stolen the car. So within the car is evidence of ownership of the car. That was not an issue in this case. He wasn't. There was no issue that Travis was driving someone's car without consent. And whatever else was in the car, for instance,
you have no insurance, you have no driver's license, you have these dealer plates.
But all of those things were accomplished at that time. They were. I mean, he had cocaine in his pocket. Personally used cocaine. He said, "I used cocaine." There's really no cause. There was no reason to believe that there's going to be anything else in the car to support the fact that he had cocaine in his pocket. He did. And with regard to lack of insurance, as I think the magistrate judge pointed out, once he demonstrates he doesn't have it, he can't show it. It's a
what about
defense.
No, searching the glove box and to figure whose car is this?
But that's just an investigatory search at that point. It doesn't go to whether he has insurance. He's not saying I have insurance. He's not displaying his card. He's not saying it's my car. I have proof of it. He's got his girlfriend on the phone saying it's my car. There's nothing. Certainly the lower court, neither judge thought that there was anything that was in the car related to what they found, related to what he was ticketed for or what they found in his pocket that had anything to do with it. Indeed, Judge Stadmiller said excuse me one second here, the search of the defendant's persons and the fruits of that search are non-issues in this case. And they're also non-issues because, of course, the forfeiture issue. In its brief, the government made an admission which it had to, that regarding some of the arguments in support of the search, it admittedly, albeit unintentionally, forfeited. And I'm going to argue that the record favors the conclusion that the government chose not to make the bulk of its arguments at the district court level that it now makes here, intentionally so. Let's look at the choices the government made. It did not develop the record of the hearing to show that a second post-tow impound lot inventory search did take place, or even that it probably would take place. It did not argue in its initial post-hearing brief that the personal use cocaine found on Travis justified either a Gantt search incident to arrest or a search based on probable cause, the automobile exception. It did not object to the magistrate's finding that, quote, the government has failed to sustain its burden to show that the search of the Prius was permissible as a search incident to arrest, end quote. And in its response to Travis's objections to the magistrate's recommendations, not one word on inevitable discovery. The government has made deliberate choices. In so doing, the government acted deliberately. A common distinction we draw, if this court says in the Ortiz, the 2005 case, a common distinction we draw between waiver and forfeiture is that waiver comes about intentionally, whereas forfeiture occurs through neglect.
Thank you, Mr. Campion. We are going to give you time on rebuttal.
Thank you.
Thank you. We'll now move to Ms. Tableson on behalf of the government.
May it please the court, Rebecca Tableson on behalf of the United States. There are multiple straightforward ways to resolve this appeal because Deputy Hobbs' search of the Prius was constitutional several times over. The judgment below is therefore correct, although we respectfully disagree with the district court's criticism of the search. The district court relied on the inevitable discovery doctrine to deny the motion to suppress, and this court can too. For that doctrine to apply, the evidence must show by a preponderance that law enforcement would have conducted an inventory search had Deputy Hobbs not conducted his search.
What's the best evidence that law enforcement would have done so?
The evidence is, first, that the Prius was lawfully impounded and had to be towed, and second, the Milwaukee County Sheriff's Office policy, which was in evidence and also discussed at length at the hearing, requiring that any such vehicle towed off the highway be impounded. In multiple other cases, this court has upheld the application of the inevitable discovery doctrine on a much more attenuated factual record. I'm thinking of cases like Stotler and Sims. This case is really on all fours with Cartwright, in which an inventory search occurred, but the officer did not write it all down on a written inventory form, so it was defective in just the way Deputy Hobbs' search was defective. And this court said, first of all, not every deviation from the written policy necessarily renders an inventory search constitutionally unreasonable. And second of all, anyway, the inevitable discovery doctrine applies here.
So is the government's position that the roadside search was an inventory search or phase one of an inventory search?
Yes, I think the magistrate reasonably concluded that the inventory search, although not a perfect mapping onto MCSO's policy, was reasonable enough to satisfy the Fourth Amendment definition of an inventory search. Under cases like Florida versus Wells, an inventory search has to be sufficiently regulated to satisfy the Fourth Amendment, even if it doesn't map on to the letter of the county policy.
It's a little hard. Go ahead.
Go ahead.
It's a little hard to see that when you watch the body cam of the actual search. He's not thoroughly looking through the car. He goes to the glove compartment. To say it's an inventory search suggests that there is some measured way of looking through the car for any items that might belong to the defendant here. And that's not what I see in the body cam.
I hear you, Judge, and I don't think it's the strongest way to defend the search, to be clear. I think the strongest way is, as Judge Scudder noted, the search incident to arrest doctrine. As to just to finish on the inevitable discovery point, however, I think what my friend, Mr. Campion, is sort of missing here is the whole conceptual foundation of inevitable discovery is what would have happened had the allegedly unlawful search not occurred? And that is the question we're answering there. And so that means what would the police have done had Deputy Hobbs never gone through the car? And in that instance, the impoundment and inventory search policy is sufficient to prove that.
Is there any evidence that there actually was an inventory search at some point?
Not that's presently before the court on this record. Not separate from what was already
from the policy itself.
Exactly.
I mean, the thing that's odd about, or that I find very counterintuitive about the inventory search is that The stop is along I-794, right? That roadside along a major highway in Milwaukee, after a stop for speeding, that the police officers would be pursuant to municipal policy conducting an inventory search roadside. That seems very odd to me. That what you would do is you'd call the tow truck, the car would head to the station house or the impoundment lot, and the inventory search would proceed.
Well,
I mean, that seems to be the fair import of a
Yeah.
policy like this.
what Deputy Hobbs testified was that he went to the car to do a quick search before the tow truck came for two reasons. Search incident to arrest of Mr. Travis and an inventory search to take a quick look at what was inside the car before it was towed away.
Now, as a legal matter, do you think that his reasons make any difference whatsoever?
No, subjectively they do not. I only mean to say that the case was sort of litigated on both of those tracks from the get-go. The evidentiary hearing, investigated both the search incident to arrest doctrine and the inventory search doctrine. And to the extent Your Honor is asking, isn't this a kind of a weird thing for a deputy to do on the side of an urban highway at night? I'm offering his explanation,
No, yeah, I think that's what's created some analytical confusion. Is he may have, and he may have in good faith, held the belief that he was conducting an inventory search along I-794. But that belief or that view is neither here nor there. It just seems to me that we ought to focus on what in fact did he do. He entered the Prius, he looked in the glove box, he found a gun. And the question from there is, were Mr. Travis's Fourth Amendment rights violated as a result of that action? Regardless of the belief that this was a phase one inventory search or whatever he had running through his mind. And I'm not saying that critical of him. It just doesn't matter what he thought.
I fully agree. And for the same reason, it doesn't matter that he thought subjectively he might not find more evidence of drugs in the car after he found the cocaine in Mr. Travis's pocket. Under this court's precedent, he was still entitled under Gantt to search the car after Mr. Travis's arrest with that cocaine in his pocket.
But you didn't make that argument below.
Well,
It's hard for you to stand here and make it
Your
now.
Honor, I'm not.
Or develop the record on that.
I think I'm going to disagree on the latter point. The record of the evidentiary hearing was about both the search incident to arrest doctrine and the inventory search doctrine. As to forfeiture,
Not the search incident to the arrest because of the cocaine. Maybe because of the vehicle license and not knowing whose car it was. But I don't think there was a development of the search incident to arrest because he found cocaine in his pocket.
Well, I think I disagree, Judge St. Eve, because in the sense that the evidentiary hearing explained everything that had happened, including all those traffic violations, unlawful dealer plates, and the cocaine in the pocket, and then explained.
Other than cocaine in the pocket, there wasn't really anything else about that. But putting that aside, whether or not you developed the record, I didn't see any argument before the magistrate judge or the district court that this was a search incident to arrest because of the cocaine in the pocket, which may have been your strongest argument.
I think it's fair. I think the magistrate did find that we had forfeited the cocaine-based incident to arrest argument because he said the officer conceded that he subjectively did not expect to find more drugs in the car. That's docket 34 at 6. Again, that goes back to Judge Scudder's question about that not really being relevant.
I'm not relying on that. I'm relying on the arguments the government actually made.
So before the magistrate, we definitely made a search incident to arrest argument, citing Edwards and explaining how these
Based on the cocaine in the pocket?
No,
Yeah,
absolutely.
that's my point.
Yes, it's a little bit of a confusing sentence.
Yeah,
It says-
Edwards is all about the whose car is this and
Yes.
is it stolen and all that.
Edwards almost could not be clear that this is a search incident to arrest case. Most obviously, the dealer plates, the unlawful dealer plates on the car support a search of the car for evidence of its ownership. I mean, it's almost a slam dunk.
Notwithstanding the FaceTime conversation?
Absolutely, Your Honor. I mean, there was no evidence linking the dealer plates to the woman on FaceTime who was claiming ownership of the car. And as was explained at the hearing, the dealer plates are only lawful for a car that's offered for sale by a dealership. There was also no indication that the car was offered for sale. And even so, even if the woman had in some way claimed affiliation with the dealership, the officer would have been entitled to look in the glove box for, evidence corroborating that of the car's ownership.
Yeah, in other words, he's not legally compelled to accept an explanation on FaceTime
Of course not.
roadside.
as this court has written, the case name right now is escaping me, I just read it this morning, they're not compelled to accept the explanations offered by the suspects with whom they're interacting. They can do further investigation.
Is there anything in the record, Ms. Tableson, that shows why Deputy Hobbs puts the cocaine back in Mr. Travis's pocket?
I think the record indicates, Judge Brennan, that he needed both hands to handcuff Mr. Travis, but Mr. Campion might remember that better than me because he was at the hearing. That was my memory from the rereading the transcript. I don't think that was an issue that was disputed between the parties, though, and if I'm misremembering, I'm sure my friend will correct me.
And the reason I ask is normally when contraband arises in the inventory search, it wouldn't be given back to the defendant. That's why I raise it.
Yes, absolutely.
Mr. Campion can speak to it. Thank you.
Absolutely. I think just to quickly, I think there is absolutely no indication of on this record of waiver. The magistrate did make a pretty aggressive finding of forfeiture against the government on this search incident to arrest doctrine. And then what happened is, but we still prevailed on the inventory search argument. And then what happened is the defendant objected up to the district court, focusing only on inventory search and inevitable discovery. We responded on those points, but did not seek to relitigate the parts of the magistrate judge opinion that had gone awry for the government. And that's how the case made it to the district court. Nevertheless, the district court still did address search incident to arrest, which means that this court can too, if it wants. If nothing else, however, a full and proper application of the Fourth Amendment shows that Deputy Hobbs was doing good police work on the side of the highway at night in Milwaukee, constitutionally apprehending a felon with a violent past and cocaine in his pocket who was speeding on the highway in an unlawfully registered vehicle with a loaded gun and a loaded 34-round magazine in the glove compartment right in front of an unsecured 7-year-old child. There's no basis to suppress the evidence the Deputy Hobbs found that night. If there are no further questions, we ask the court to affirm.
Thank you, Ms. Tableson. Mr. Campion, we'll give you 3 minutes on rebuttal. If you might be able to address that cocaine question.
That was puzzling when I first saw it on the video. I don't think Ms. Tableson is off base. I think it almost sounded as if he was somewhat offended because he kind of shoved it back in and he got ready to handcuff him and then took it out again after he said you're under arrest, and he said, "You lied to me." And I climbed Mr. Travis. "I'm sorry, man, I do cocaine." I don't know if he was actually offended or not, but it was an odd thing. He was a man on an island at that time. He was the only police officer there. I don't fault him for that. I want to address a couple of things about this scene. Coincidentally, this scene is right out my window. I don't know if Judge Brennan, you're aware, our office moved across the street. We're on the 23rd floor of that lovely Corals building, and I'm looking at this scene every day.
All 3 of us have driven this quite a bit.
And there was room to do what he did. He did approach from the passenger side, and I think there's evidence of that because Deputy Hobbs drew the child's mom to that scene for the exchange of a child at that very scene. So he did have room. And another thing about Deputy Hobbs, I believe he testified during the hearing that he's a field training officer, and 2 underlings showed up to watch him do his work, and he showed him how to package up a gun and that kind of thing. So this is a guy with at least some level of experience and respect within his community. Judge Scudder, I think you said it doesn't matter what he thought. And I understand his subjective notions can be placed aside at times. I think what does matter is that this is a deputy, field training officer, and the only witness for the government who was asked to articulate about this policy. And he did. And what he articulated is that he did it right then and there. That's where he did the search. I think I appreciate the government's concerns for any person, certainly a police officer as well, about his reputation. That said, there was no finding that he was discredited, just a finding that he made some aggressive errors. And this is what should happen when a police officer does that. There should be findings that, no, this is constitutionally invalid. So what happened at the district court level is perfectly appropriate with those findings. The last thing I would say is, to get on my high horse, but 2 things. The doctrine of inevitable discovery is what this court has said is not to be invoked lightly, and it shouldn't be. And we're also talking about the rule of law, and every time one of my clients gets sentenced, the court talks about the rule of law. Well, the rule of law should apply here. The arguments the government forfeited should be forfeited, and the government has failed to demonstrate that there probably would have been a search. It's a preponderance of the evidence standard. It's not that much, but they gave us nothing. Thank you very much.
Thank you, Mr. Campion. Thank you, Ms. Tableson. The case will be taken under advisement. We're now going to move to case number 6. This is Appeal 22-3191, Horizon West Condominiums versus Travelers Indemnity Corporation of Connecticut. And Mr. Ganser, we're going to begin with you.
Thank you, Your Honor. May it please the court, I'm Mike Ganser from Milwaukee, Wisconsin. I represent the Horizon Homeowners Association. I'm joined today by about 15 people who own those condo units, or some of those condo units, and we're all here to ask you today to reverse the district court's decision. The reason is this. This is an application of an insurance policy to a certain set of facts. I don't think the law is particularly unusual or anything here. It's just a matter of looking at this policy.
Mr. Granzer, before you get too far down the road, may I clarify something, please? You are not appealing the district court's ruling that the individual unit owners are not proper plaintiffs here, are you?
I am not.
Okay, and you're also not appealing the district court's dismissal of the bad faith?
I am not.
Okay, thank you.
Clearly that is now arguable because that was dismissed. So
Yes,
that's
okay.
fine.
Just wanted to clarify it. Thank you.
But we're here to talk about, though, is this policy, which is really what's an all perils policy. And that is defined in the policy itself. It says that where a covered cause of loss is one in where the risks of direct physical loss are not otherwise excluded. So the bottom line here is that everything's included unless it's excluded. So I think that gets us as the plaintiff appellants off to the first mark, and that is that I think the burden then shifts to the other side to say, what are the exclusions that apply here? And in this particular policy, what we see is kind of a hodgepodge. There's a haphazard and conflicting result here because, you know, what insurance policies do, and I'm sure almost any lawyer in this room would not do this, is that they just add portions to the main policy as exclusions or add-ons or whatever it happens to be, which gets you with a kind of a sloppy document, and I think that's the case here. What we're talking about then is, what does the defense hold as the reasons that this is excluded? Now, one thing that I would note, and this is located on the Wis-Janney report, that is the report of travelers, and in the appendix at 133-134 of that document, the writer indicates that there's limited to water infiltration and that sort of thing. It's number 6 in their conclusions, and it says, we conclude that this statement is highly speculative and not supported by the current conditions and assessments. Now that's important to us because our position is simply this, that the exclusions here and their own expert, they cannot tell us what is excluded. They haven't done it, they don't have the proof for it, and even though this was dismissed in the beginning as a motion to dismiss 12b-6, the fact of the matter is that they have the burden and they didn't meet it. There is nothing that their expert says that will conclude that there is an exclusion to this policy because they can't count on it.
Mr. Ganser, to follow up on that point, building is still standing, is that correct?
It is.
Residents have all left the building, is that correct?
They were given 15 minutes.
And then so the current status is who takes care of the building? Is there some kind of a caretaker or?
Well, no, we've been working with the city of Waukesha on this, and largely it's premised upon what happens here today with this argument and the ultimate decision of this court. But the city of Waukesha has actually already commenced the initiation of tearing down the building. So there were some matters here. They're apparently going to take it all down and then fold in the girders, and that should take care of tearing it down. It's an expensive process, though. So we've been working with Waukesha for quite a while on this. So the real question in that matter is not that the work will get done. It's going to get done very soon. It's a matter of who's going to pay for it. Okay. So we've worked that out with them. As we,
Mr. Ganser, you've alleged in your complaint that the damages are caused from two separate things, from the building's structural errors and the city's orders. And there is a specific exclusion in the policy for ordinances or law. It's called the ordinance or law exclusion. Why wouldn't the piece of your complaint that deals with the city's orders, not the separate piece about structural issues, but the city's orders, be excluded under that provision?
We believe that provision, there are two parts to that provision. The first part is this, that the order wasn't like an original order. It's not like something like an eminent domain or something like that. It's simply that the engineers for the city of Waukesha saw that there was this problem and asked that the order be issued. So it's not the primary mover here. The primary mover is the fact that they determined the building had structural instability. The second part of that is what we've talked about is the fact that a public policy should not allow for there to be that provision in there. Because as we said in our brief, that puts these homeowners in a position where they've got to determine whether they stay in the house, stay in those condos until it starts falling down so that they can get covered. Instead, they comply with the lawful order of the city of Waukesha safety order. So how can this insurance policy be countenanced when you look at it and it says, well, if the building falls down, we'll cover you. But if somebody says the building might fall down, we won't. I think that puts people at risk, and that is contrary to public policy. That, in fact, in the McPhee case that I've cited in our brief, it talks about that.
Mr. Ganser, can you clarify one argument you advanced in your brief? In a place or two, you argued that the policy is providing illusory coverage.
It is.
Do you mean that in part or in whole?
I think I mean it in part, but I'm very tempted to say in whole. And the reason I say that is because if you look at their position in this case, virtually any common matters that might cause structural default here, or loss of structural integrity, I don't know what they are. I don't know what they're covering. So, yes, I've mentioned that in the brief. I do believe that it's partially illusory in that I can't identify when a structural problem would be paid for, even though we think that it should be. So that's why I say it. What's the expectation of the policyholder here? They say, geez, our building is no good. We've been kicked out of our homes. Insurance must cover this. And then we get to the policy, and as I said, it's pretty unusual policy. Because
there is some coverage in there, and we're not arguing about it so much, but just trying to discern the meaning of this. It's a form of additional coverage, collapse coverage, right?
Right.
And that, as best I can discern, that additional coverage on collapse would be like some kind of, the facility just kind of caves in on itself, or just, God forbid, people in it, but just falls down or something.
Right, and we've seen that in Florida, and then I think we recently saw that, was that in Nebraska or Iowa, where some of these buildings, these 1960s
The reason I point that out is that a building's not going to collapse unless there's a structural problem of some kind, absent like
Agreed.
a natural disaster,
Yes.
causing that. But that's not illusory, right? In that situation, if it just collapsed on itself, you'd say, we're going to invoke that additional coverage and submit a claim.
That's right. That would take it out of the illusory. That's why I said in some respects it's partial,
Yeah.
but that I was tempted to say that it was wholly illusory. But you're right. If it does collapse and people are still living there, then there would be coverage. But again, that points out what we've been saying from the beginning, that's contrary to public policy. You can't put people in that position where they've got to make that determination.
Can I trouble you with one more question?
Yeah.
It'll help me to hear you in the courtroom articulate it. You make the argument that the rust exclusion is vague or ambiguous. Can you spell that out a little bit?
Yes, I can. There are 5 covered or uncovered instances where water can enter the building. Okay, the old inclusio unis et exclusio alturis applies here. So there are obviously some water intrusion events that are covered. So the way the policy works, but we can't identify that cause, but if the policy works that way and it's an included water intrusion, then we've got 2 parts of the policy at odds, the rust provision and the water intrusion provision. And where in a policy those 2 things are at odds, then the policy holder should win. And that's exactly what the law is, and that's exactly what our argument is.
All right, Mr. Ganger, we will be giving you rebuttal time.
Very
Thank you.
good. Thank you, Your Honor.
Let's move to Ms. Chaptik now on behalf of the appellee.
Good morning, Your Honors. Michelle Chapnik on behalf of Travelers. May it please the court. There's no question that this entire situation has been devastating for the Homeowners Association, but this is a contract case, and contract cases aren't decided based on emotion. The contract has to be enforced. It was a specific contract that was issued, underwritten, and a premium was paid for certain risks. And the court in all Wisconsin courts enforce their contracts. The central issue here, they make the argument this is an all perils policy and all that, but the central issue in this case is we have to look at the insuring agreement. The insuring agreement of this policy says that there has to be direct physical loss caused by a covered cause of loss during the policy period. This is a 12B6 motion. So we're constrained to the pleadings and we look to what they've pled. The only quote unquote loss that they've pled that occurred during the policy period, which started in May of 2021, is the issuance of this evacuation and raise order.
Doesn't that go to Mr. Ganser's argument, the Hobson's choice for the residents of, here we've got a safety order, but then we've got a policy that doesn't apply?
Well, the thing is, it's not a Hobson's choice. I mean, it's not that Travelers is saying, if you stayed in the building, we're going to pay for the building if you violate this order. That's not the issue here, because there's no coverage even if they had stayed in the building and violated the order. I mean, if you look at the policy, it has a very specific exclusion for collapse. Doesn't cover collapse. And specifically, it doesn't cover the structural issues with structural integrity. It gives back a little bit of coverage under the additional collapse provision. And that little bit of coverage that it gives back is it must be abrupt and it must be from one of the 4 subsections. But it specifically says, but the danger, the fact that the building is in danger of falling down, that doesn't come within the additional collapse coverage.
So how does this work in a situation where a building abruptly collapses? There had not been a removal of the balcony and a location of the rust and the corrosion and all of that. The building just spontaneously just comes down. Nobody expected it that way. And then it turns out, lo and behold, upon examination, there was a major rust problem with some of the structural support of the building. How's the policy operate at that point in time?
Well, you have to look at the different subsections of the additional coverage for collapse. Was there knowledge by the insureds?
No, in my hypothetical, there's not. There's an abrupt collapse, and it turns out it was because the steel support beams had rusted out, but that's learned later. How's the policy work?
The policy would look at, it would exclude, if the cause was just from the rust, it would exclude the cause from the rust. And you would have to look at the additional coverage for the collapse.
Well, the reason that I put that hypothetical out, it seems like this is not a point that Mr. Ganser makes, but it seems like the policy is a bit at odds with itself on this. In other words, an abrupt collapse that is later determined to be caused by rust. I don't know how the policy works.
Well, if you look at the additional coverage for collapse, Your Honor, under Section 2A, if it's an abrupt collapse and it's caused by building decay that's hidden from view, so under your hypothetical, no knowledge of the building decay associated with rust, then there would be coverage under the additional coverage for collapse. But if it was known to the insured prior to the collapse, that's an exception under these circumstances.
So in that hypothetical, the travelers would not invoke the rust exclusion?
Well, the building decay, it would, this is beyond any of the arguments in the briefs, but
I'm
there is
just trying to
case law.
understand the policy. I'm just trying to understand the way this thing is structured.
Well, the way that it's structured is that, number one, they have to have and this is their burden, direct physical loss from a covered causal loss in the policy period. They haven't alleged that. They've alleged building instability that occurred in 2020 that they knew about prior to the policy. That's not within the policy period, and that's what the district court noted. And then they've alleged that there's some balconies that were removed. That's not a loss. That was a decision to do some work on the building. There was no loss associated with balcony removal. But what they have alleged, if you look at paragraphs 39, 40, and 42 of their amended complaint, what they say is our loss is as a result of the issuance of the evacuation and the raise order. And the ordinance or law exclusion, as well as the governmental action exclusion, directly excludes that sort of circumstance. And
it seemed to me the loss was the inability to live in the apartment anymore. That's their physical possession,
but it's because of the issuance of the evacuation and raise order, which it was a law.
It's because
that they had
of
to
the
comply
structural damage. I mean, if you say a direct physical loss, you might be pointing out the rust or some of the other things that it would fall within an exclusion. But it seems to me they've alleged these are our units where we lived and we can no longer live there. That sounds like a physical loss to me.
Well, it has to be caused by something,
but that's a separate provision. I'm just addressing your argument that the contract says and the policy says you have to have a direct physical loss. That sounds like a direct physical loss to me if you can't live in your home anymore, your unit.
Well, it has to be from a risk of direct physical loss, and what caused them to not be able to live in there? The issuance of the evacuation and the raise order. And that's the only thing that occurred within the policy period. Now, they point to two issues as to why they say the ordinance and law and governmental action exclusions don't apply. One being the fact that it's taken away by this legal liability provision, which doesn't exist in this policy. If you look at the forms of the policy, there's no legal liability coverage. So there's no removal of those exclusions. And by the way, this is not a manuscripted policy. If you look at the bottom of the policy, it says it includes copyrighted material from Insurance Services Office. This is a typical policy that is issued across the country. These provisions are not unique to this policy, and we've cited numerous cases in our brief that have upheld all of these exclusions that we've relied upon and that we've discussed here. So it's not like this is, and they've all been upheld as clear and unambiguous. I want to address very briefly the public policy argument that they make, and that is that I guess what they're saying is that somehow we're not encouraging them to, or we're telling them that they shouldn't stay in the building, or they should stay in the building, and that would create coverage, but that's not the case. As I pointed out a little bit before, that the fact that whether they stayed in the building or didn't stay in the building, there's still no coverage under the circumstances of this case when the building is in quote-unquote danger of falling down or caving in. And the additional collapse coverage specifically spells that out. As to the issue of illusory, to be illusory, that means that coverage is never triggered under any circumstances. And that's not the case here. There's many risks that are covered by this policy. And there are circumstances, as we discussed a moment ago, under the additional collapse coverage that gives back some coverage where there is coverage. So it can't be illusory if there is some coverage that is being offered here.
And if you had to describe that coverage, how would you describe it?
The additional collapse coverage?
No, the coverage that you says does exist for the risks.
So I know. Can I answer?
That's fine, absolutely.
Okay. Under the circumstances here, had there been a actual collapse of the building, as Judge Scudder pointed out, and if it complied with one of the subsections of the additional collapse coverage and not just in danger of collapse, there might be coverage under those circumstances. But they're not under these circumstances. So we'd ask that the court affirm the district court. Thank you.
Thank you very much, Ms. Chapnick. Mr. Ganser, we'll go back to you with 3 minutes for rebuttal.
Thank you, Your Honor. The court, and I think it was Judge Brennan, talked about the Hobson's choice here, and counsel indicated the problem here. She said that the homeowners had to honor the order and rather than to stay, but that's exactly what the problem is here. They talk about it's not illusory, but the only example cited is the sudden collapse as a give back, some kind of a give back here on the in the policy. So I think that in many respects it is an illusory policy.
Well, there's some broader. So the point that wasn't made by she just ran out of time is, damage from a bursting pipe, a fire, things like that. Nobody's arguing that it would not cover a fire.
I agree.
Right. So it's at least non-illusory as to certain very typical commercial losses.
I would agree, and that's what I'm referring to only as structural losses.
Yeah.
And the intended and expected coverage by the policyholder here.
No, you're clear on that.
Okay.
You're crystal clear.
Thank you.
Mr. Ganser, I know this isn't necessarily relevant to the legal issues, but did your clients have individual insurance that covered them here?
They did, but I can tell you I'm representing a bunch of them and trying to get that. Those aren't paying because they're saying this is a common element type of situation and we're not going to cover. So they've got their own homeowners, but nobody's covering. And I think one company did pay one relocation. That's about it. So as indicated, these people out of the house, still owe on their mortgages, have to find alternate housing. There's a guy sitting here today is 80 years old, had to go back to work driving a concrete pump truck. So this has been rather devastating, and we recognize this as a contract matter as indicated by counsel. But at the same token, there's a real human toll here, and certainly the expectations of these people are consistent with the fact that they believe that they had coverage, and all of these conflicting provisions that may or may not apply, I think give credence to their position that we expected coverage and that coverage should be afforded in this case. There are just too many things that are in opposition here to say that this policy is a good policy written by a good lawyer who had it all well figured out. Thank you very much, Your Honors.
Thank you very much, Mr. Ganser. Thank you very much, Ms. Chapnick. The case will be taken under advisement. We're going to move now to case number 7. This is United States versus Aubrey Jones. This is appeal 22-3218. And Mr. Beal, we're going to begin with oral argument from you.
May it please the court, this case centers on two questions. First, what objective evidence must the police have of the commission of a crime before they seize a person? And second, what is the evidence in this case of the commission of a crime? The parties do not disagree as to what the legal standard is. It's the standard Terry standard. Police officers may detain a suspect for a brief investigatory stop if they have a reasonable suspicion based on articulable facts that a crime is about to be or has been committed, and the inquiry is an objective one based on the totality of the circumstances known to the officer at the time of the stop. But the parties do not agree as to what the facts are. Mr. Jones was walking along Cermak Road and turned onto Kirkland Avenue. The police officers, while back in their police station, observed Mr. Jones on a pod cam while he was on Cermak. He was gripping his pants, which did not have a belt. Judge Coleman found during the evidentiary hearing that the officers could see that Mr. Jones was gripping something, but could not tell what it was. The evidentiary hearing has the following colloquy. The prosecutor asked, "What did it appear to you watching this footage that he was gripping?" Objection. This is page 13 of the transcript of the evidentiary hearing. And the court, in response to the objection, the court says, "Let Mr. Beal make his objection clear." And I stated the objection is he doesn't know what Mr. Jones was gripping. The court says no, and he hasn't said what he's gripping. He can't say what, but he can talk about he's gripping something. At this point, it's very clear after his walking for 20 seconds and never letting go of his crotch area, he's gripping something. But then, later the same day, without receiving any additional evidence, Judge Coleman issues a minute order denying the motion to suppress and stating in the minute order, officers observed Jones on pod gripping a large object concealed inside the crotch area of his pants, which, based on its shape, appeared to be a gun. And the government echoes that in its brief, saying a review of the entire video captured by the pod camera at 2200 South Colwyn shows the defendant was continuously gripping a long, rectangular-shaped object within the right side of his pants. We submit that the video does not show that the video.
It looks to me from the video, Mr. Beal, just to, in the interest of time here, it looks to me like, especially when the camera zooms in, okay, that he's gripping something about midway down his leg, right? Because you can kind of see his fingers bend and he's holding something. Now, obviously, we don't know what that something is.
Yes,
but
that's what the judge found, is that he was gripping something, but
no, right,
we didn't know what it was.
I've watched the video. My colleagues have probably watched the video. So my question is, if that's the impression I have from watching the video, I don't know what he's gripping, but he's clearly gripping something about midway down his leg.
And
How is that finding by the district judge clear error? The factual finding?
because the judge found that it appeared to be a gun. And we submit, looking at the same thing you've looked at,
Right.
that there's no reason, there's nothing that, I mean, the government has, after he was tackled, there's a picture of the gun sliding down on the back of his leg. And that can be seen to certainly have indicia of being a gun. The object, whatever it was he was grabbing, there's no indicia of being a gun. And carrying something of unknown nature is not a crime. That's the problem we have, which is he was walking, carrying something. He may have had something. I mean, he could have. We know now that there was a gun. Although the gun, I can get technical. The gun was in his underpants, not his. He was actually trying to just make sure the gun didn't fall out of his pants like it did after he got tackled. It was sitting in it because at the beginning of the video, and then in that brief 3 seconds in the middle, and in the end, he's walking around without holding anything.
Yeah, let me ask you one other thing that stuck out to me, and maybe it's irrelevant. You can tell me that is as Mr. Jones is walking down the sidewalk and that camera is picking him up. On several different occasions, he appears to be quite concerned about what's happening around him. He's looking over his shoulder. He appears on the camera a bit jittery, as if he's, someone's about to approach him, or somebody's looking at him, or he's about to be confronted. Is that, one, do you think that's an accurate observation in the video? And two, do you think it's legally relevant?
I think it's not, well, I would not say that's a completely unfair observation. Mr. Jones had been, as he told the officer, he had been shot once in this neighborhood.
He just seemed jittery. He seemed nervous. That's my perception.
Yeah.
And to add on to Judge Scudder's point, at one juncture towards the end of the segment of the video that we saw, he kind of goes around the corner of a brick building. He's not there long, almost like a readjustment, and then keeps walking. Thoughts on that?
Well, again, he's readjusting something, and we don't know what it is. And is there any reason to without having any notion as to what it is, that there's a sufficient indicia it's a gun, so that the government has an objective fact rather than mere speculation? I mean, that's what the balance is. And we submit that simply walking down the street with an unknown object and grasping it is not doesn't constitute a criminal offense, and even on a reasonable suspicion level. I mean, if there were, because they talk about the shape appearing to be a gun, and the government says a long rectangular shaped object, that was before the takedown. Those characteristics were not visible. I mean, we submit, I mean, I've looked at this video multiple times. So after he was taken down, it was obvious. So they've got just some object which certainly the police have an intuitive instinct to say, oh, he probably has a gun, but that's not what the legal standard is.
Why isn't it sufficient on this record, though? And again, as Judge Scudder noted, the standard of review is clearly erroneous for factual determinations, that you clearly see some type of bulge, that he's holding something in his pants. He's in a high crime area. He's looking around like he's suspicious. And you have officers who are trained and experienced in this. Why isn't that collection of facts sufficient here, again, on a clearly erroneous standard of review?
Well, first of all, in terms, as I mentioned with the facts, Judge Coleman did, with respect to what's on the video, Judge Coleman doesn't have anything that gives her particular insight above what this court would have, just seeing what's actually fit on the video. But secondly, in terms of it's pretty much a normal inner city neighborhood, which is a dangerous place, and it's not altogether surprising that Mr. Jones, who's been shot once in that neighborhood, is nervous just walking around. And in terms of the police, they talk about it being a high crime neighborhood and so on, but there are no specific instances or no statistics of the nature of that neighborhood offered by the government during the hearing. They just make very general statements.
That wasn't contested at the hearing, that it's a high crime neighborhood. And the officers who policed that neighborhood said it's a high crime neighborhood. That sounds like that would be sufficient.
Well, it's I think the problem is that makes it no different than virtually any neighborhood on the south and west side of the city of Chicago, and that doesn't give the police carte blanche to stop anybody they want to just because they're in one of many high crime neighborhoods.
Mr. Beal, can I get the benefit of your reaction to one other question? Sure. Okay, it's this. So let's forget the video altogether for a minute. Just categorically set it outside your mind. Okay? When the police pull up, we can't get this all on the camera, but it's from the video, but it seems like they make eye contact, or your client makes eye contact with them, and then he runs.
Yes.
So regardless of the conclusion, this debate about what findings were, okay or not okay on the video, why under Illinois versus Wardlow is that flight alone in that area not enough to justify the Terry stop?
Well, I think that Wardlow says, or Justice Stevens' concurrence says that flight alone should not be enough.
No, focus on the majority opinion in Wardlow, though.
I guess what I would say is he fled 10 or 15 yards. It was inherently futile flight. It was in the context.
So too on the facts of Wardlow. Well,
what we submit, it's Mr. Jones' way of telling the police he didn't want to talk to them. And he fled from them. Wardlow doesn't. The Justice Stevens' interpretation of the majority opinion is that flight alone is not necessarily sufficient. So that's what I would rely on, is Justice Stevens' interpretation of the majority opinion. And what I would say is that, Mr. Jones was a young man in an inner city neighborhood, and many young men in those neighborhoods have uncomfortable relations with the police and don't like to talk to them. And he was manifesting that uncomfortable relationship. And that should not be then expanded to constitute a sufficient basis for a Terry stop.
Thank you, Mr. Beal. We will give you some rebuttal time. Now we're going to move to argument from the government. Mr. Stone.
Thank you, Your Honor, and may it please the court. Brandon Stone on behalf of the United States. The district court properly denied defendant's motion to suppress after holding an evidentiary hearing, during which it reviewed pod and body cam videos and heard testimony from the arresting officer and the defendant. During that hearing, Officer Martinez clearly articulated the particular facts that led him and his partner, Officer Smiley, to conduct a Terry stop of the defendant. Those facts include Officer Martinez's discussion of the high crime neighborhood in which narcotics activity and gang shootings had recently taken place. It also discussed the officer's observations of the defendant's appearance on pod camera video, where they watched him glancing around nervously, gripping a concealed object in his pants, which they stated that they believed to be a firearm. And then third, that when the officers arrived on scene to conduct a field interview, which is what they stated they planned to do upon reaching the defendant, they observed the defendant flee from them immediately. And as Officer Martinez testified, it was these facts all in their entirety, the totality of these circumstances that led the officers to stop the defendant and recover the firearm from the right leg of his pants. I want to first address defendant's argument regarding the exchange with Judge Coleman regarding, it's really a response to an objection by Judge Coleman that the AUSA is asking a question about what the officer spotted on the pod camera video. And if I can turn to page 13 of the transcript, yes, Judge Coleman says he hasn't said what he's gripping. She also says, right now he can't talk about that he's gripping something. She says it's very clear that he's, after walking for 20 seconds and never letting go of his crotch area, he's gripping something. Now, that was in response to an objection from defense counsel, regarding what the officer knew at the time. I want to point out, first of all, it's not about what the officer knew, it's about what the officer reasonably suspected at the time. And as the officer stated, just 2 pages later in the transcript, after talking about recovering dozens of firearms from individuals in these sorts of circumstances, he said, in response to, based on your training and experience and based on the crimes that have taken place in this area, did you have any suspicion at this time about what Jones was doing? Yes. What did you believe he was doing? I believe he was concealing a firearm inside of his pants. And so, defendant's argument that Judge Coleman somehow made an inconsistent factual finding during the hearing in response to an objection just doesn't comport with what's in the transcript. I want to go back to also Judge Scudder's question about nervousness and its relevance to the totality of the circumstances here. As the government pointed out in its brief at page 20, Colbert case says that nervous behavior is suggestive of wrongdoing. It's suggestive of criminal behavior. And as Judge Coleman mentioned in the suppression hearing, she said, "You're looking every which way but loose." She made the finding that he did indeed start looking around nervously, and you can see on the pod video that the defendant is doing so. Third, I want to address this question of high crime neighborhood. As Judge St. Eve pointed out, this was uncontested at the hearing. Officer Martinez testified that he had patrolled this neighborhood, he was familiar with this neighborhood, that he knew of recent narcotics activity, and he knew of recent gang shootings in the area. Defense counsel had a chance to cross-examine him on those statements. That was declined. And so now defendant in his reply brief wants to say that we need to provide statistics or reports. That's just not the case. Those facts were introduced at the hearing. He had a chance to cross-examine, and he declined that. And finally, I just want to address defendant's flight. Judge Scudder, you asked a question about defendant's flight. Under Wardlaw, in a high crime neighborhood, flight is relevant to consciousness of guilt. I think it calls it classic behavior, showing evidence of wrongdoing. And so it of course is relevant to the totality of the circumstances here.
Mr. Stone, this may be a little bit off point, but are you aware, have there been constitutionality challenges made to these pod cameras? This is different than a poll camera where there's a warrant, some type of probable cause determination that might be pointing towards an alleged drug house. This is just on the street.
Your Honor, I'm not aware of any constitutional challenges to the pod cameras. I assume you're asking about what they can and can't see and the degree of zooming in. Is that?
Well, and it's just the general civil liberties concept. I mean, we've got obviously cameras at intersections, but I'll be asking the same question of Mr. Beal. I just want to get the benefit if you had any knowledge on that.
I do not, Your Honor, but one thing I do want to point out is in our brief, we did talk about what is a pod camera and how they're operated. One thing that I would point out is they're clearly marked. So they're up on the poles. This is in our brief at page in footnote 2. They're marked with CPD logo, and they're in plain sight. So most of the residents in this area know that these pod cams exist and that they're being operated.
Thank you.
And so lastly, I just want to point out that this was good police work here by the arrest and CPD officers. They were watching a high crime street corner on pod. They observed the defendant. behaving suspiciously and gripping a concealed object concealed in his pants. These facts provided them with the ability, they wanted to go investigate. They stated during the suppression hearing they wanted to conduct a field interview. When they drove over to the defendant, he fled immediately, dropped the water bottle he was carrying in his left hand, continued to clutch the concealed object in his right hand. That gave the officers reasonable suspicion to conduct a Terry stop, during which, after a brief foot chase, they tackled the defendant and recovered a loaded Glock 23 loaded with an extended magazine, concealed in his pants. This stop was permissible under the Fourth Amendment, and the government therefore respectfully asks that the court affirm the judgment of the district court.
Thank you very much, Mr. Stone. Mr. Beal, we're going to go back to you with 2 minutes for rebuttal. And Mr. Beal, if you might begin with my inquiry concerning civil liberties challenges to these types of cameras, or any thoughts you have on that.
Unfortunately, I looked into that at the beginning of the appeal, and the Seventh Circuit has upheld, I think Judge Flom wrote the opinion,
Thank you.
That those are constitutional.
And that's different than, say, a poll camera with a probable cause determination having been made.
I don't remember the details, but I remember that when I looked into it, I discovered it was going nowhere because of that opinion. It was going nowhere in this case.
Thank you. You may continue.
Your Honor, this case presents the question of where the line is between officer speculation and objective evidence of criminal conduct on the part of the defendant. I would submit that Mr. Jones was engaged in odd but not obviously criminal conduct, in that there, as I've looked at that repeatedly at the video, you cannot see the outline of a gun, even what a conspicuous bulge it doesn't exist on the video. I realize there are these other aspects, but it raises the question of what the rights of an individual in the inner city is, and that I would submit that this case does not have sufficient indicia of criminal conduct to go over the line from just odd behavior to reasonable suspicion of the commission of an actual crime. Thank you.
Thank you very much, Mr. Beal. Thank you very much, Mr. Stone. The case will be taken under advisement. We are now going to move to our final case of the morning, Appeal 22-3155, United States versus Brandon Ellis. And Mr. Hillis, we will begin with you.
May it please the court, counsel, my name is Daniel Hillis. I'm with the Federal Public Defender's Office. I represent Mr. Ellis on this appeal. It's a single issue, and it's a very straightforward one. The district court, in pronouncing sentence, relied on errant, incorrect information, in our opinion, and that is because the district court termed possession of a firearm as a violent crime. Judge Scudder, you caught my ear earlier today when you noted in a prior case that possession of a firearm is not a violent offense. That is as clear as can be here. We have the elements of the offense that we could easily look to. We can also look to the Eighth Circuit's decision in Roberts to say that it's a status offense, much like you termed it earlier. So that was simply an incorrect statement of the law. Why is that important? It's because here, in pronouncing sentence, the judge relied on that determination that it's a violent offense to vary upward by 54 months. The guideline range in this case was 24 to 30 months. The judge did not look kindly on having the firearm. Fair game, judges are entitled to their own sentencing philosophies. They can engage the facts as they fall before them, but they're not free to reterm the law to call something a violent offense when it in fact isn't. And so that is the difficulty that we face here.
So you're relying on the court's comment that you can't keep committing the same violent crime. That's the basis. And do you agree if the violent part were taken out, if the court had just said you can't keep committing the same crime, that you wouldn't be here?
Sure, much like I would in a civil case if somebody said, I'm not giving you the job because you're a woman. If you take that, because you're a woman part out, then you don't have anything to complain about, or because of your ethnicity, etc. But we cannot take from the record the thing that is the grievous instance here that allows for the relief that we seek, Judge.
What's your best argument, Mr. Hillis? You know what your adversaries on the other side say about reading the transcript in its totality and contextually that the district court was talking more about just the risks of violence and the problems that guns, pose on the streets of a city like Chicago.
I think the district court did both things, Judge. So the judge was appropriately considering the dangers that firearms present. So if I had a firearm and I brandished it, for instance, then it would be saying to a person, you need to think, because now you're provoking violent responses from other people who might have guns, from the police, etc. But that's not what happened here. We look at paragraph 6 in the PSR, and it says that the glimpse of the firearm was caught mostly because he lifted up his shirt or something to kind of then...
This is another one of those pod cases, right? Pod camera cases,
right?
We call them.
Not litigated, so not pressed. And so we're looking just at what the facts are known to the judge in pronouncing sentence, and it wasn't that he did anything to provoke violence. Merely having a gun is not anything that poses violence. Otherwise, the whole Second Amendment may be, fair game on this, right? But you're allowed to, and perhaps even as a felon, allowed to have a firearm and issue for a different day under Bruin. But nevertheless, we're looking here at what the facts are. Paragraph 6 of the PSR, a glimpse of the firearm was caught. It was in his waistband. He did not retrieve it. He did not motion towards it. He didn't do anything to suggest he was going to be imminently engaging in any violent conduct. He simply possessed a firearm. Back to Roberts, that is not violent conduct. Therefore, it is wrong to term this a violent crime. And we look at appendix pages 24 and 25, and we don't get to separate out the parts that we don't like any more than I would like to be able to do that in any criminal case where the language disadvantages me. I have to take it as a whole, as I'm doing here. It's not a stray remark, because it is something that's central to the judge's decision in affecting what the sentence ultimately is in this case. Now, all of that being said, I don't want to miss the chance to address the court's question, should it have any, about standard of review, because we believe very definitely that the standard of review here is de novo, and it's for a couple of simple reasons. One is to make a determination is not something that requires a defense attorney to make an objection to. That is properly deemed an exception.
It seems that we addressed this in the application of Rule 51 in the U.S. versus Wood case.
We've addressed it numerous times, and therefore I'm not warm to the idea that this is somehow a waiver or it requires forfeiture analysis. It doesn't. Shaw is a recent instance where the Court of Appeals has said this is not something that requires plain error review. This is something when the judge makes the mistake, we are left then to argue about its effect.
I don't think there's any question you're right about that.
Good.
I don't. I'm surprised. I mean, I've seen this a couple of times from the government. We're going to ask about it here in a second. But I'm surprised at arguing that.
I don't fault the government for making arguments that it thinks it can get traction on, Judge. There's sometimes we win things, sometimes we lose
Wood
things.
is as clear as day on this.
Thank you.
Because otherwise, the judge is imposing sentence, and you'd have to say, hold on. I know how judges would react to that.
There's a member of the panel that drafted Wood for the court. The one point in Wood that is fair is that the best practice is to raise that comment on the spot so it's dealt with, right? That language is in there, but we're clear that you don't have to interrupt, and it's subsumed within the sentence and therefore subsumed within the judgment, and therefore you can argue it on appeal.
That's our take on it. Yeah, I don't have anything to add to that. I think that's correct. I think that's been correct since Bartlett. I think that's also reflected in the federal rules. But nevertheless, if the court did have questions, and it seems that you don't, so I'm happy to.
Let me ask you one more question. I don't want to hit this issue too hard, but you know our case law as well as anybody does, Mr. Hillis. Is our case law unclear on this in your view?
Unclear
on this Wood-Shaw point?
I don't think so. I think that if we look at what Bartlett says, we have our answer. I think if we consider what Shaw recently said, again, it's just reiterating what this is. So we have instances, and Miller's another one, where once the judge makes a misstatement, we don't expect people to interrupt judges when the judge has made his or her determination. We accept what it is, and we grumble about it on the appeal. So today we're grumbling. But as a final matter, we again, just point to what legal authority is on this. So we have a due process right to be sentenced on the basis of accurate information, and that's not something to take lightly here. So if due process says that we get that. And if the Supreme Court has made that clear in the Tucker and Townsend line of cases, this court has made that clear in U.S. Welch versus Lane, and the list goes on. We just have to look to see, did the district court rely on the incorrect information in the pronouncement of sentence? We don't have to trace back very far. We look at pages 24 and 25. The judge says this is a violent crime. We know it's not. And then the judge gives the sentence that he does, and it's an enormous upward variance. He wouldn't say it if it didn't affect his penal philosophy and shape the sentence that he ultimately imposed. So with that, I have nothing further.
Thank you, Mr. Hillis. We'll now move to Mr. Didwania on behalf of the government.
May it please the court, Vikash Didwania on behalf of the United States. So let me start with the standard of review because I know the judges have some questions about that. When we look at Miller and we look at Shaw, one of the things that comes out is one of the best practices is for the district court to ask at the end of pronouncing the sentence whether there's anything that counsel would like to address, any objections or issues that they would like to raise. And here, I would just implore you to look. The district court judge here asked numerous times of both attorneys to, was there anything to address? And in fact, both sides did raise issues with the sentence that the district court had announced. The government raised an issue with the conditions of supervised release, and then the defendant raised several issues, including whether the district court should have taken into account the time that he spent in state custody. So I don't think the suggestion here is that the defendant should stop the district court, interrupt, and raise the issue. But at the end, it would have been very possible for the defendant to say, Judge, you mentioned this was a violent crime.
How do you get around Wood, though, where something similar happened, and the district court said, is there anything else I need to address? And while I agree with you, it certainly would have been the better practice to say, well, you said a violent crime. We were very clear in Wood that alone, is there anything else, is not sufficient.
And Your Honor, we relied on Miller, and I think the facts in Miller are pretty close to what happened here, where in Miller the judge made a statement during pronouncing the sentence about the hypothetical criminal history category, and then the court found that plain error review applied. But I guess I would just end that by saying I don't think the standard of review matters here. Plain error review or de novo, I think we get to the same result, and so I'm not sure it's necessarily an issue that needs to be decided in this case.
No, look, I really appreciate your candor on this. I think I thought you might say Miller, and I wonder if you're saying Miller in complete good faith. It's out there, it's circuit precedent, all that, and I wonder if there's just there's daylight in our case law on this. There's just some ambiguity because Mr. Hillis, the cases he's pointing to, and we just haven't been as clear as we could be on this. That's our problem. That's not of your making.
And you're free to address any issues, obviously, as you write the opinion, Your Honor. But again, it's not necessarily something that needs to be clarified in this case, because I don't think it makes a difference here. Going to the argument about the two words, violent crime, the district court did not commit an error by using those two words in a 6-page explanation of the sentence that it imposed. And when taken into isolation, maybe those two words weren't the most artfully worded, but Judge Scudder, as you mentioned, when you're looking at the totality of the context of the sentencing hearing, what it reveals is that the judge was talking about the danger and the substantial risk of violence that occurs when felons illegally possess guns. The district court specifically said that the violence that is brought on by the use of these illegally possessed guns by felons and the need to deter such conduct. That's on page 24 of the sentencing transcript. I believe it starts at line 5. And here, this notion that maybe the district court erred and thought that violence was an element of the offense is just not supported by anywhere in the record. It wasn't in the plea agreement, it wasn't part of the plea colloquy, it wasn't the government's version of the offense, it wasn't the pre-sentence investigation report, it wasn't in the sentencing memoranda, and it wasn't presented by the counsel at argument. No one here argued that violence or violent act was an element of the offense. And Mr. Hiller mentioned that provoking violence or committing a violent act are not parts of the offense, or were not an issue here. And again, nobody suggested that the defendant here actually provoked violence or committed a violent act. So the notion that the judge somehow, when using the words violent crime, assumed that a 922 G1 offense has as an element of the offense violence is just not plausible in light of the record. And the second point I would make is, even if the court were to agree with the defendant's interpretation of those two words, they were not the driving factor for the sentence here. So Mr. Hiller mentioned they were essential to the district court decision, but in fact the district court explained what was essential to its decision. It noted what, quote, require a sentence that is above the guideline range, in this case where the defendant's, quote, refusal to change his behavior in the face of 2 prior convictions, and, quote, the danger he placed the police officers in and the rest of the public. That was at page 26 of the transcript. And the court elaborated on that danger, not only the defendant possessing the gun in a crowded neighborhood, but then fleeing with that loaded gun when he was approached by the police. And then noted multiple times the defendant's criminal history, how he had been convicted of illegal gun possession twice before, and the need to deter that conduct. And finally noted the defendant's mitigation argument. The defendant's history was not particularly mitigating. He had positive family and childhood experiences.
This was a fairly hefty sentence, almost 3 times above the high end of the guidelines, not what we usually see.
It was, Judge, and as Mr. Hiller mentioned, the judges are entitled to have their sentencing philosophies, and of course, the substantive reasonableness of the sentence is not challenged on this appeal.
Correct. I was surprised Mr. Hillis didn't make that argument.
I would just suggest, Judge, that although a hefty sentence, the district court did provide a lengthy, thoughtful explanation for the sentence that it did impose. The district court did not commit any error or any misinformation about the nature of the offense here. And even if it did not rely on those 2 words in imposing the sentence. And so therefore, we ask that the district court's judgment and sentence be affirmed.
Thank you very much, Mr. Jadwania. We'll now move back to Mr. Hillis for any rebuttal.
We try never to surprise the Court of Appeals by making one argument or not making another, and given the absolute dearth of success that anybody's ever had making the substantive reasonableness, thus my silence. So the court wishes
I understand why. I'm not criticizing you for that at all, but it was a high sentence.
Yes, it was. And Judge Guzman has given high sentences on these. We don't have many ways to attack his decisions, but today we do. And if we had a clear indication from the court that it wishes to have opportunities to make substantive reasonableness arguments, by all means, include that language in whoever drafts it, and we'd be glad to read that. But we do have some things to complain about a little bit for what the government said, and Mr. Jadwania does a terrific job. But it doesn't have to be the driving factor for the imposition of sentence. We just need it to be incorrect and that it be relied upon. How do we know that it's incorrect? Because 922G1 is not a violent offense. How do we know it's relied upon? Because it's on the page of the transcript. He cited from page 26 of the transcript where the judge is giving his final imposition of sentence, or rather a statement about what it should be. We'd have to look back very far to page 25 to say where he called it a violent offense. It is not, so it's an incorrect statement of law. It's inaccurate. It's relied upon, obviously, and it is a central feature, because if we're looking at somebody who's a recidivist, and our primary concerns are not just that he's a recidivist, but the types of crime that he commits, and you say you can't keep committing violent crimes or offenses of this type, what are his offenses of this type? It's the possession of the firearm, and it's not violent. So that's a problem. What to do about when the judge makes a misstatement? If we had some rapid fire arrangement where we can immediately request from the court reporter something that caught our ear, we know the judge said something wrong, and we get the transcript, we can tap the brakes and say, in a very more thorough response to the judge's question, did I miss anything? Is there anything that you need to tell me? We don't really get to interrupt the proceeding and say, could the court reporter please read back the last 3 pages of what the judge had said so I can double check to make sure. This is all done on the fly. It didn't catch anybody's ear, but we know today, by looking at the transcript with the benefit of that this was an incorrect statement. We don't need more than that. And we don't need to point to anything else the judge said that was right. We just have to focus on something the judge did was wrong, because that's the due process problem that presents itself here in this case. And so that's all I have to say, unless the court has any further questions. We think that Tucker and Townsend light the way here. Due process, well, it's not always the thing that courts want to hear as a constitutional matter. When it does present grounds for relief, we hope that it will be given.
Thank you very much, Mr. Hillis. Thank you, Mr. Didwania. The case will be taken under advisement. That will complete our hearings for today.